Hello, and thank you for being here. I'm Nina Schabach. I'm the Pittsburgh Program Coordinator for Pennsylvanians for Modern Courts. I'll give you a brief overview of what we do. Pennsylvanians for Modern Courts is a nonpartisan nonprofit that envisions a Pennsylvania judicial system in which everyone is assured impartiality, accessibility, and respect. For over 35 years, PMC has worked to educate all Pennsylvanians about the courts and how to navigate them with confidence. While we are not offering legal advice today, we hope this presentation is informative and educational for you all. On behalf of PMC, thank you for being here. You will be receiving a recording of tonight's presentation as well as a questionnaire. And if you fill out the questionnaire, that helps us provide more workshops just like this one. I will also be introducing Judge Nicholas Martini, who previously worked as a public school teacher, as supervisor of the City of Pittsburgh's Federal Community Block Grants programs, and as municipal manager for Stowe Township. He is an Allegheny County native and the son of a judge himself, and he was elected to his judgeship in 2021. So Judge Martini, I will start sharing the presentation at this point, and you can direct me.
All right. Thank you, Nina, and thank you to the Allegheny County Law Library as well as Pennsylvanians for Modern Courts for allowing me to host this workshop tonight, which is the nuts and bolts of filing a small claim, $12,000 or less, which is also called a civil complaint in our district courts. I am one of 12 City of Pittsburgh district judges who hold jurisdiction within the City of Pittsburgh in Allegheny County. So as Nina said, I've been on the bench since January of 2022. And I usually, in my personal district court, which is located in the West End, I represent 16 West End neighborhoods in the City of Pittsburgh. My office is in the West End proper. And on a yearly basis, I probably handle anywhere from 250 to 300 civil cases, which are cases involving money disputes between contractors and litigants. There's a variety of things, which I'm sure we're going to go over tonight in the presentation, but that is generally, so a civil complaint of $12,000 or less can be filed at the district court level. Anything in excess of $12,000 must be filed at the Court of Common Pleas. So if you're seeking a civil judgment in excess of $12,000, you cannot file it in our district court. That must go to the Court of Common Pleas. Thank you, Nina.
We've gone over a bit of this here. So again, for your reading pleasure, look forward to more of our workshops coming up. We've been, again, active for over 35 years, since 1988. And we do have a series of workshops coming up in Philadelphia and Pittsburgh, with more to come in Pittsburgh, especially now that I am here in the city. So back to you.
Thank you. So yeah, just as a sidebar, that I've been a Pennsylvanians for Modern Courts partner since taking office. I usually host 2 workshops a year. I usually do one spring and one fall. I've hosted workshops on emergency protection from abuse orders, landlord-tenant court. What else have I done? Definitely those. Yeah, but I usually host a landlord-tenant one yearly and then another one. So, and we did the understanding the magisterial district courts. I was on a panel last October with 2 other Allegheny County district judges. So I'm happy to host these workshops for Pennsylvanians for Modern Courts, and there are over a dozen. So I'm sure at some point I'll be able to dig into other ones as well. So just as an overview, though, where does civil claims or small claims court fit in? So yeah, as was already said, so they would mainly, if $12,000 or less, are going to fit into the magisterial district courts. We actually have 46 district courts in Allegheny County, 12 in the city, and then there are 34 in the suburbs, which is not in the City of Pittsburgh. These are not jury trials. They are simply it's a trial between a plaintiff and a defendant in a civil matter, and the district judge will decide the monetary judgment as in who will be awarded that, whether it's the plaintiff or the defendant. We do have jurisdiction over criminal preliminary arraignments. We have jurisdiction over preliminary hearings, summary criminal offenses, which would be traffic and or non-traffic offenses, truancy, building code violations, those would be non-traffics, private criminal complaints, which are complaints filed by the Commonwealth on behalf of an individual. We also handle those. We handle civil matters. which is what we're going to be going over tonight, landlord-tenant complaints, which that property must be within the jurisdiction of the office that it's filed in. So that's always a residential complaint, but that's also a civil matter, which also cannot exceed $12,000 at our level either. What is the difference between magisterial district courts and the Court of Common Pleas? So the Court of Common Pleas is the next level of the judiciary, which is above the magisterial courts. And as I mentioned, they would handle any landlord-tenant complaints or civil complaints in excess of $12,000 being sought. We're not a trial court, which is what the Court of Common Pleas would be. They have the ability for you to have a jury trial, whether it be a civil or a criminal matter. You have the right to a jury trial, which at our level there is no jury trial. We are also, as the blue, so you can appeal our decision to the Court of Common Pleas. So a landlord-tenant, a civil matter, a summary appeal, whether it's a traffic or a non-traffic, any of those can be appealed to the Court of Common Pleas. But as also magisterial courts are not a court of record. So that's any appeals to any of these are heard in the Court of Common Pleas. And that just gives you the appellate courts in the state, which are Commonwealth Court, Superior Court, and then the Supreme Court is the highest court within the Commonwealth. What is important to know before going to court? Okay, so terms you should know before going to civil court. The claimant, the injured party, the person who is harmed by the conduct of the defendant now seeking an award of money damages from the court. One thing to note too regarding civil claims court in our level, we are handling money only. So any filings within our court, it's got to be monetary. You can't file a civil complaint saying that I want a certain piece of property back or I want my dog back. All we can do is assign a monetary value to that. So if you're claiming that someone has taken, property of yours, an animal, an iPod, a cell phone, and they won't return it, all you can sue for at our court is the value of that item. Any district judge cannot force somebody to give you back your phone, but you may be entitled to whatever the value of that phone is. So that's also something important. We do not deal with real property with this. It's monetary only. As said here, money damages, that is a payment of money imposed by a judge. Defendant is the party who caused the injury that is an issue in the case. That is the person the claimant has brought the suit against. So if you're filing a civil claim, you are the plaintiff or claimant. Then the defendant is the person who the plaintiff is claiming caused this damage or this breach or this money loss. So the burden of proof. So the burden of proof in a civil matter is not beyond a reasonable doubt. It is a preponderance of evidence, meaning which party does the judge believe proved their case 50.1%. That is the burden in a civil matter. It's a lower standard than beyond a reasonable doubt. What is more likely than not is the burden that we go for, which is the preponderance of evidence. Terms the amount in controversy, the amount of money that is an issue at the case, the amount of money the winner of the case would receive if they win their case. Contract. This is very important in any civil and or landlord-tenant matters, which also do fall under civil. A contract, which is an agreement between two or more parties. It can be written or oral. An individual purchase life insurance that they've entered into a contract. And then what is the breach of this contract? Who breached the contract? What part of it was breached? So that's one of the crux issues that the plaintiff must claim and prove that there was some kind of breach of this oral written contract, what have you. Which party was negligent? Which party breached it? How did they breach it? Reasonable care, the degree of a care an ordinary, rational, and prudent person would have exercised in similar circumstance. Contempt of court, when an individual is disobedient or disrespectful towards the court of law, they have said to be in contempt of court. Powers such as issuing financial penalties or short periods of jail time. So we actually, as a sidebar to this, magisterial district courts, we are not actually allowed to issue anybody in contempt of court. That is for the common pleas only. So we do not actually have that power. We certainly can have you escorted out of our court, but we don't have the power to find you in contempt of court. Why go to civil claims court? If you're seeking an award of money damages up to or less than $12,000, then, as I mentioned before, you can bring your case to the magisterial district court where the accident occurred or where the defendant lives. Typically, there are two types of cases that are brought before this court: negligent and contract actions, which is true. Usually, the bulk of these cases are some party was negligent or there was some breach of contract. That's the bulk of civil matters that I see and that most district judges will see. This court cannot, this is another great point too. This court cannot hear a case being brought against a Commonwealth party government, such as the Pittsburgh Regional Transit, which would be Port Authority, formerly known as, or the Department of Human Services. So if you're trying to seek some kind of civil action against the city of Pittsburgh or an authority like Pittsburgh Water and Sewer Authority, we cannot take those cases. Those cases must be brought before Commonwealth Court, which is an appellate court above common pleas. They handle government type of suits. We do not. Every once in a while, a party will try to file against a government entity in our court, and pursuant to rules of civil procedure, as mentioned here, we cannot take those cases. The statute of limitations. So this is also something important to look at and remember before you actually file a civil case. These have a statute, meaning how long you have to file a case from when the action occurred. So in Pennsylvania, the most important item here, in Pennsylvania, you have 2 years for an injury and property damage cases and 4 years for a contract case. So if you're claiming that someone damaged, your fence, your retaining wall by their negligence, and it happened in 2020, you missed the time you only have a 2-year window when you're claiming that occurred. Now, if it's a breach of contract case, you paid a contractor to build you a retaining wall, and you paid him in 2022, and he still has not done that. Well, you had 4 years, so you in theory have, in reality, you have 4 years from when that contract commenced to bring suit regarding him not completing the job. And then, depending on the circumstance, the statute of limitations clock can stop and restart. So that's also a good point. So you may be able to get around potentially filing the exact 2 year and 4 year if some of the job, say, was completed 2 years ago and then there was a stoppage, then it restarted. So your clock could, as it mentions here, stop and restart depending on the circumstances regarding it. And that would be different in every case, and that would certainly be up to the claimant to prove to the judge, where I think this should go beyond maybe the 2 or 4 years because ABC occurred. So that would be the judge's call if they feel that you're still within your statutory, limit there. So the 2 and 4 years is generally that's the period of time to be mindful of. Okay, so suing a business or corporation. If you're unsure if a business or corporation has business in Allegheny County and thus may be sued in court, you should contact the Pennsylvania Corporation Bureau, and their link is provided here, as is their phone number. So that would just give you a little information on where they do business, basically, if it's in the county or if it's not, where it is. So mediation. So mediation is a private negotiation between the claimant and the defendant that occurs outside of the authority of the court. So before trial, the parties to a case have an opportunity to engage in mediation. We do have a program in Allegheny County that is called Just Mediation. I've used them sometimes to handle landlord-tenant matters, and a lot of other judges do as well, that maybe will enter in some kind of resolution before coming to court. But as this slide basically mentions, though, that this has to be done out of court. This is not to be done in court. This would be a private meeting that you're going to have between the plaintiff and the defendant. And then also the agreements must be in writing and signed by all parties. Binding means that once an agreement is put in writing and signed by both parties, it is final. It is extremely important someone signing the agreement through mediation fully and clearly understands the agreement. So that could be presented in court, or you could hold it, and then in the event something doesn't happen, if the work's not completed or the money's not paid, etc., then you kind of have this agreement that you could present if you need to. But that's, once again, that would all be done outside of court. But that agreement could be used in court if you would get to that point. Going to magisterial district court for a civil claim. So these are just some generals to kind of, bring with you and know that you should present these things at court if you get there. So before going to court, make sure you have all of your information and evidence to bring with you. You don't need it at time of filing, but you need it for the hearing. So pertinent items, any kind of contract, any time, just a good general rule of thumb, anytime you're entering into some kind of agreement with a contract to do any kind of work, you should get a written contract. It should specify the project that's going to be done, how much money it's going to be in total. Is there a deposit, maybe a third down, a third halfway done, and then a third at completion, or whatever kind of arrangement you're going to make. But whatever this agreement and arrangement is, it should be signed by the contractor and the homeowner or the person entering into this service. Any photos. So pictures are great to show, exactly what you're trying to talk about wasn't done, isn't correct. Picture's worth 1,000 words. And any people with civil hearings with me that show a lot of pictures, that's very beneficial because it makes everybody understand exactly what you're talking about, what you're saying is not correct, what wasn't done. It just brings it into light for everybody. Any emails, texts, phone call, well, obviously not a phone call, but voicemail. But any kind of communication that the parties are having, if it's relevant to the case, saying that I'm going to, sometimes you'll see something like, I'm going to be there Thursday to finish the job. That's communicated in a text message. Then that doesn't happen. Then there's a text set next week. Hey, I thought you were coming here to do this. So any kind of trail that you have is great just to prove that we're trying to make contact. He said he would give me this money. So any things like that are very important to proving your case. So remember, any of that. Also, too, anything you're going to bring to court, you should make copies of for the judge and the opposing party, because don't always assume that the courts are going to be able to make copies of 100 pictures, that you're trying to present. So if you're going to try to present these things, it's helpful to bring copies. Like I said, you have a copy for you and 2 more copies, one for the opposing party and one for the judge. So everybody has the same items and everybody's looking at the same things. General understanding of the law. Is there a contract or agreement? So is it written or unwritten? Has it been broken or breached? Is there a duty owed? Is there a hazard for which there is notice? Is there a trespass? Has the duty been broken? So, these are just generally, is there a written contract? What was it for? How much was it for? What was supposed to be done? What didn't occur? Who didn't who didn't provide the service they were supposed to, et cetera. So as I said, who was involved, who are the parties, and what are the damages? Is it a property issue? Is it a personal injury? So, these are all things that generally apply in civil matters, and that you need to, be able to explain to the judge during court. Examples of factual documentation. So contract action documents, obviously documents explaining the agreement between you and the other party. Yes, any kind of agreement that you have, whether it's written in a contract form, if it's emails, if it's a text message, any kind of written communication is very important in proving your case here between you and there's yes, as I mentioned, emails. Yes, then obviously other documentation such as photographs, diagrams, any invoices, estimates, canceled checks, proof of payment, anything to prove your case, it is pertinent that you bring it with you. And then negligent action documents. So, and once again, some of these are the same ones, but what kind of communications have you had? What things haven't been completed per the contract? Have just basically, sometimes, you maybe have made payment in full before a job was completed, and then you're saying, well, they didn't finish parts, C, D, and E of this. So you should have pictures of what wasn't completed to try to prove your case, as well as if you had to bring in another contractor to finish items because some things were not done, you should have estimates and or repair bills from them to show that why these items were not done. Earnings reports. if you're trying to say, you lost time from work because of something that occurred, like maybe a vehicle accident, anything like that. So, but I mean, you can look through some additional of those items in negligent action documents. But like I said, anything you think is important in proving your case, you need to bring with you the day of the hearing. I'll have, litigants come into my court and say, oh, well, judge, you know what? I didn't bring that item. Well, now's when we need it. So, I mean, it's important to bring any items you think are important, bring them, even if you don't have to present them, just bring them. Because if you don't bring it, you can't show anybody it. How do you file a complaint? Determine which court the complaint should be filed in. So you're going to file this in a magisterial district court, as I said, which you can as long as it's $12,000 or less. If it's higher than that, it has to go to common pleas court. So how do you determine what district court you need to file this in? So here's a few ways to do this. So where's the property located? If you're talking about a claim of a contractor case, say, so you need to file that at where the work was supposed to be completed. That is the appropriate venue for that. So if this is at your house, you need to file it at the local district judge regarding where your property is located. Or you could do it where's the individual located. So I mean, it's basically where the cause of action arose is your go-to as to where you should file this. You could file it at where the contract was signed. If it was signed at, say, a contractor's office, you could file it in that jurisdiction. So there's a few different. There's always 1 to 2 to 3 places you could potentially file a civil complaint, but it's got to fit into one of those criteria. Where agreement says complaint should be filed, where occurrence or harm occurred. So sometimes every once in a while, I'll get a vehicle accident that happens in my jurisdiction. Neither party may live in my jurisdiction, but because the vehicle accident occurred in my jurisdiction, that's the appropriate venue as to where it should be filed. So, I mean, like I said, you have to, and when in doubt, usually you can always call the district court and ask them to say, hey, you know what, I don't know exactly if this is the correct place to file it. And usually our staffs are all very good. They'll figure it out with you, telling you where, oh, you know what, you can't file it here. You need to file it here. So, I mean, my staff does that quite a bit, and they will, if we're not the appropriate venue, we'll often give that person that here's the district court's phone number, call them and make sure this is where you need to file it. So when in doubt, just call. But I mean, those are kind of the criteria that where the cause of action arose, where the incident occurred is your best bet as to where it should be filed. Or like I said, you could also do where an agreement was signed. If you go to a physical place and sign an agreement, that's the best place it should be filed. How a case gets to court. So the claimant must file a complaint with the court once they find the appropriate venue. You will need to find the, okay. Yeah. Oh, here's a link, which this is Montgomery County, I think this says here. But yeah, so, but whatever the county that you're seeking to file this, there's links all throughout the MDJS portal, the different, the judicial districts. We're the 5th judicial district in Allegheny County. So we have all our districts courts listed there. So you'd get the address and information. But there are fees involved with filing a complaint. They could be waived if you show that you cannot afford the filing fee. So that would require a plaintiff filling out an informa pauperis form stating that you don't have the necessary financial means to pay the filing fee. So you'd have to provide documentation, though, to prove to that's the judge's decision if they're going to take the case with an informa pauperis or if they're going to require you to pay the filing fee. That's totally the judge's call. But you need to provide documentation if you're going to file for an informa pauperis showing that you only make X amount of dollars a month, etc. Excuse me. The court has staff who may answer your question and may assist you in completing the necessary forms, but they are not allowed to give you legal advice, nor is a judge. Be prepared in detail to write the facts of your case on the complaint. So you need to have something written on the complaint as to why you're filing this case. Breach of contract, vehicle accident. I'm claiming that the defendant hit my car and did not have insurance. So, I mean, you have to give some kind of description as to why you're filing the case. So that, and because the defendant needs to be made aware why they're being sued. You can't just leave that blank or just put, something generic. You need to put some kind of detail as to why you're filing. and the amount that you're seeking as well. That's all required on the civil complaint form. Is there a form? Yes, there is. This is the general blank civil complaint form. See, which will require an original signature on the bottom of the plaintiff filing it. It will show the filing fees and the either certified mail cost or the constable hand service cost. So, once a civil complaint is filed in our office, we must schedule a hearing within 45 to 60 days. There must be service on the civil complaint in order for there to be a hearing held. And whether that's by certified mail or constable hand service, that's up to the plaintiff to determine which one of those they want to pay for up front. But if there's no service by certified mail or constable, we cannot have a civil hearing because the defendant needs to be made aware of the hearing, that it is occurring on this date, this time, and then they have the right of their intent to defend. So, and then hiring an attorney, obviously, every party, whether it be a plaintiff and or defendant, have the right to hire an attorney to, present their case for them. So that's totally up to either party. A lot of civil cases I get, they are, pro se, meaning that neither party is represented by an attorney, and then some I get both have attorneys. So it just varies. How a case gets to court. Service. So I might have skipped ahead a little bit on this, but an individual who is suing someone must make the other person aware that they are being sued. This occurs after the complaint is filed. It is known as service. Similar to filing a complaint, there is a fee for the court to serve legal papers on the individual's entity being sued. But this fee may also be waived if the complainant can demonstrate that they cannot afford to pay the fee, which goes back to the informa pauperis that you would have to fill out at time of filing. If the judge grants your informa pauperis request, they will waive the certified mail fee as well, and or potentially constable service. So that all varies court to court, but service, as I already kind of mentioned, but service is paramount in a civil case. So if there's not certified mail service and or constable hand service, the case cannot proceed. The defendant must be made aware they're being sued, and they're to appear at the court on a specific date and time. I am sued. What do I do? So if you're the defendant in a civil case and you get your notice that you're being sued, and here's the hearing date is set up at this district court at this date and time. So you have to put your notice of intent to defend into the court, which makes the plaintiff aware that you are defending this claim. So make sure you attend the hearing on the notice you receive from the court, or file with the court a request to reschedule, which is also known as a continuance. That should be written. If you're going to request a continuance, it needs to be in writing, whether I accept them handwritten, I accept them mailed, I accept them emailed, but any continuance request must be in writing. We do not take those over the phone. They must be in some sort of writing. So if there's service made and you're the defendant on the civil case, you do not put a notice of intent to defend, and you do not show up at the hearing, and there's no continuance that was granted, the plaintiff automatically wins, which is called a default judgment. The court will send you a letter saying the date of the decision was made and the amount you have to pay. This will also create a lien on any property you own, including your home. This means what the other side may be able to claim your property, including by taking money from your bank account. A judge might also ask the other side to prove you owe them money. If the judge decides that the other side did not have enough evidence, they might schedule a new hearing. But generally, if there's a default judgment entered, I think we're probably going to get to the certified judgment. But yeah, but if you do not intend to defend, service is made, and you don't get a reschedule or you don't come into court, it's going to be a default judgment for the plaintiff at that time, as long as service happens. Some other responses to a lawsuit: negotiate a lower amount or use a mediator to find a compromise. Both sides can negotiate to come up with an agreement before going to court. You can also use a mediator who can help you discuss and negotiate. On the day of your hearing, the court may be able to provide you with a mediator with the dispute resolution unit. I mentioned Just Mediation. Here's their link. And then also Good Shepherd Mediation is another one, which is, I haven't used them. But just mediation is definitely been used quite a bit here in Allegheny County. But, you know, I mean, and sometimes, you know, people will talk in the waiting room before they come into court, and sometimes they will come in with a, you know, basically a resolution before we have a hearing. So you certainly can do that. Either party has the right to do that upon getting notice of the complaint. This is just maybe a way to, it's mentioned, you know, so you maybe do not have to go through the court procedure. Responses to a lawsuit. Go to court and challenge the case. You can hire an attorney. You can call your insurance company, depending on if it's a insurance type of case, or you can also represent yourself, which is called pro se. So, you know, you can, let's see here. But obviously you should be ready to explain your side of the story to the judge. It's your job to prove your case and your evidence as to why the plaintiff is not correct in what they're seeking. You know, so I mean, you know, once again, you have to bring any proof with you: contracts, disputes, text, emails, bills, checks, you know, receipts, anything to try to prove your case. You need to bring with you if you're the defendant. What a claimant may bring to the hearing. Okay, I actually mentioned this. I bring 3 copies of any document or evidence. Yes, as I said, so you know, one for yourself, one for the opposing party, and one for the judge. Any contracts you have, any checks, any receipts, any bills, any invoices, photographs, estimates, anything to prove your case. If police reports, if it's maybe an auto accident or property damage, and there's a, you know, police report taken, you know, so anything of this nature you need to bring with you. Put documents in a binder with tabs, try to be organized. That's definitely helpful. That's a good tip for anybody. It definitely aids a lot of people, you know, just in presenting their case. It looks orderly. It's easy for you to find things. If the judge says, oh, do you have a copy of that bill? Oh yeah, here, it's right. You know, it just makes it quicker and a lot more orderly if you have things prepared instead of, you know, just papers being in just a big pile and you don't really know what's what. So just be mindful of that. You know, but I mean, anything with you to prove your case, you need to bring. Text messages. I'm fine with people just showing me their phone and just, you know, pointing, giving here's the text messages. That's fine. Some people print them. That's fine too. But you don't have to. But you have to have the phone and be able to pull it up, you know, in a short order amount of time. What a defendant may bring to the hearing: witnesses to try to prove their case, any cross complaints made against the claimant in supporting evidence. So a defendant has the right to file a cross complaint. So if you do that, there has to be service to the plaintiff notifying them that there's a cross complaint filed. And then any possible defenses: the statute of limitation has passed, improper venue, improper service, improper defendant. Any other evidence, once again, same thing, you know, documents, pictures, contracts, checks, receipts, invoices, text, emails. It's both parties kind of have the burden to bring documents that are, you know, similar and or, you know, different, but they could be the same documents. You could be disputing part of the contract. You could be disputing payments that were made. So anything to try to help you prove your preponderance of evidence case, you need to bring with you. Rules to follow in court. A trial is a formal court proceeding and is conducted accordingly. Where business, formal attire if possible. Maintain composure and be polite to all parties. Always address comments and questions of the judge, unless the judge states that a party may ask someone else or directly a question. Never interrupt anyone. Each party will have their opportunity to explain their case. When addressing the judge, it is best to begin with, "May it please the court," or "Your Honor." Important, always address the judge as "Your Honor." I mean, it's you know, it shows respect. It shows, you know, the proper decorum for the courtroom. So, I mean, but, you know, don't, everybody gets their, in proceeding, so in a civil proceeding, the plaintiff's going to start off the case. This is the order of how this will go. The plaintiff starts off the case saying why they believe the defendant owes this amount of money or should be liable for it. Then after the plaintiff, and they can call any witnesses to prove their case if they have any, or they're just simply going to talk about their complaint, their evidence, etc. Then it is the defendant's turn. The plaintiff goes first, the defendant goes second. The defendant can call witnesses to prove their case. They also can show documents they have or say why they don't believe they, you know, are responsible for this money, etc. So that's the general order Plaintiff first, then the defendant. And then the plaintiff can, depending on what the defendant presents, the plaintiff then can, have the right to basically re-question or re-examine any defendant's witnesses and or evidence presented. Then the judge, after the conclusion of all of the presentation, the judge has up to 5 days to make a ruling. They do not have to rule immediately. They have 5 days to weigh the evidence, examine it, and issue a judgment. It must be within 5 business days after the hearing. I went, Nina, I jumped ahead, I think, a little bit on that, but who will be present at the hearing? The district judge, the plaintiff, any witnesses. Obviously your lawyer, if either party has one, the defendant's witnesses, and once again, a defense lawyer, if there's one there. The courtroom is always open to the public as well. So there could be someone just sitting in there if they're observing for the day, or if they're maybe in there waiting for the next case. It just depends. So what will happen at the hearing? The magisterial district judge will explain the procedure to you. Don't be afraid to ask questions. Tell what happened that caused you to sue the defendant. Show any papers, bills, receipts, or letters, contracts, etc., that you have to the district judge. You will probably be asked by the other side or possibly the district judge. Then your witnesses will be allowed to tell what they know about the case. The defendant will be given the same opportunity to ask questions and can ask questions of the defendant. So that's, as I mentioned, I went over that kind of once and twice, but that's basically what happens at the court proceeding. So what happens if you win? So if you're the plaintiff and then the judge decides you proved your case on the preponderance of evidence. So if you succeed, you will get a judgment on paper saying that the defendant owes you a specific amount of money. The other party may arrange to pay you in installments, which can last up to 12 months as set by the district judge. However, the defendant has 30 days to appeal the decision to the Court of Common Pleas. You cannot collect any money until after the 30-day appeal period has passed. Remember, the court does not pay you, and in most cases, it is your responsibility to file the judgment and collect the money from the defendant. The losing party does have the right to appeal, which will delay any collection. If you win and the defendant does not appeal within 30 days, you, the plaintiff, may be able to go to the district court and ask for an order of execution be entered with by the magisterial district judge. The plaintiff must ask for this order within 5 years of the judgment. That's for order of execution. So you can get a certified judgment also after 30 days has passed, and if there's no appeal filed, which you could file with the Department of Court Records, which would place a lien on the defendant for that judgment amount. But once again, nothing can be done until after 30 days has passed from the hearing, because that is the appeal period. Here's appealing a decision. If either party wants to appeal the judge's decision, they must file a notice of appeal with the clerk of court or the prothonotary. In Allegheny County, that's typically the Department of Court Records now. They handle that, as we don't have a clerk of court anymore or a prothonotary. A lot of counties do. We don't anymore. We have a Department of Court Records which handles all of that. The notice of appeal will be served on the other party. Once they receive the notice, they have 20 days to file a complaint. The appeal will be scheduled for an arbitration hearing. This means a panel of lawyers will act as the judge and will hear the case and evidence de novo, which means a new trial, without knowing what happened at the lower court. The arbitrators will reach a decision, and if any party is unhappy with that decision, they could file another notice of appeal. This case will then go to the Court of Common Pleas and will be heard by a Common Pleas judge by themselves. At this point, appeals can become very complicated and expensive, so legal representation is helpful if you get to a Common Pleas appeal that you're requesting for a Common Pleas judge. Collecting money damages. Complainants are responsible for all collection efforts should they win their case and the judge awards any money damages. Most judgments will typically order payment in one lump sum or stipulate to other collection methods. A complainant cannot sit on their judgment. They must be proactive in collection efforts or obtain a judgment renewal to extend time. Common ways to collect: personal income, personal assets, future income assets, professional licenses, or business income. Here's some other resources: the Pennsylvanians for Modern Courts, PA Courts website, Allegheny County Bar Association Lawyer Referral Service, Pro Bono, and Neighborhood Legal Services. These are all legal representations and or information regarding the courts that could be helpful with civil matters.